What happens when freedom of religious expression conflicts with a business's desire to do business? That is ostensibly the argument before the Supreme Court this week in the case of Samantha Elauf. Elauf applied for a job at an Abercrombie and Fitch outlet, a job for which her interviewer thought she was otherwise qualified, a job she didn't get. Why didn't she get the job? Because she wears a hijab, a Muslim head covering. And it was felt by the store's management and regional management that the head covering didn't fit with the store's look policy. Now, ultimately, the court is going to have to decide where her rights begin and end and where the store's rights begin and end. But actually, I wonder if this really is about religious freedom at all, or if this isn't yet again a case where litigation is being used when really what we need is conversation and imagination. Now, I admit I come at this with a premise that she should have gotten the job and that there is something weird about failing to figure out how that could work. I mean, after all, this is a store that's in the fashion business. Is it really not possible if there was some way to expand the notion of what an appropriate look was for Abercrombie and Fitch to include young, well-put-together Muslim women who honor the tradition of head covering? I don't know, it just seems to me that that could have been done, but we won't even know because no one tried. And that's the failure of conversation. The truth is, she probably needs to do a little better job of explaining what was going on, why she did this, and they certainly had an obligation, I think, not to simply go back to her and say, no, there's no job here for you. They design clothes. Figure out, or at least try to figure out, some way to do what fashion is always doing. Broaden the range of appeal. Make it accessible. Redefine in a way that still feels consistent with the overarching aesthetic. That's the whole industry. Not to mention that look policies are kind of strange. But we'll have to have that conversation another day, because for right now they are deemed to be legal. And to the extent that they are legal, people will not get jobs because they're too short, they're too tall, they're too thin, they're too fat, they have too many piercings or not enough piercings. As long as look policies are going to be legal, then we better have imagination policies and conversation policies, especially when it comes to fashion, that do what fashion does best. Reimagine and expand beauty. Reimagine and expand possibility. So whether you intuitively, as I do, think she should have gotten the job because it's actually the right thing to do, or you feel, as I do, that look policies are a little weird at best, whatever your feelings about that are, and whatever the court decides, the takeaway in this case, it seems to me, is we need to be able to imagine bigger and talk more if we want to make the most of an increasingly diverse culture which still wants to well represent specific traditions, be they fashion traditions or geographic traditions or any other traditions. It seems to me that's the real opportunity here. How to actually blend and combine in ways that feel they have real integrity, both for the East Coast look that Abercrombie and Fitch wants and the 1,500-year tradition that this young woman honors. We should be able to do that, right?